Today, we are talking about how to prove liability in a dog bite case. Yes, the strict liability rule under the Dog Owners Liability Act in Ontario simplifies the liability aspect of dog bite cases because the owner is held liable regardless of their knowledge of the dog's aggressiveness. But there are some other elements of proving the negligence, and I'm going to go through 8 of those that you should be aware of. So, we're going to go through the 8 things you need to know about proving liability in a dog bite case. I'm Natalie Gerry, the principal lawyer with Gerry Law. Let's get into it today. So, the 8 things that you need to know, let's start with documenting the incident. So, you always have medical records when you go to the hospital, and your lawyer can help to get those. Those medical records are essential because they show the injuries that were sustained and they show the treatment, the diagnoses, and any follow up care. Another important way to document what happened is to take clear photos of the injuries. So, this includes the injury itself as it heals, immediately after, all of those elements. You also want to get photos of the location of the dog attack. You also want to get any visible damage, torn clothing, or even a picture of the dog if possible. The third way you can document the incident is you can get the contact information for any witnesses and collect statements from them so you can get their version of what happened to corroborate your story. The second important thing to know about proving liability in a dog bite case is to identify the owner. So it's essential that you know who owns the dog, and this may involve speaking with the dog's owner if they're there, or the neighbors, or local authorities, or any witnesses who are around. You also want to make sure that you have the owner's insurance information. If the owner has insurance, then it's good to get details about the insurance policy because an insurance policy may respond to your claim for damages. The third thing to know about establishing liability is you do want to look at the dog's past aggressiveness. So you could look to previous incidents. It's good to gather evidence of any prior aggressive behavior or previous attacks by the dog. And this can include police reports, veterinary records, or witness testimonies. Another important factor is the breed information. In some cases, breed characteristics might be relevant, but liability in Ontario does not depend on breed. Getting into step 4, you want to demonstrate liability under the Dog Owners Liability Act. So, as I mentioned, there is strict liability. So, meaning that if someone is bitten by a dog, then the owner is presumed to be liable. So, you need to show that the dog caused harm through a bite or an attack. Under Section 2(1) of the Dog Owners Liability Act, the owner is liable regardless of prior knowledge and regardless of negligence on the owner's part. The other issue that comes into play is contributory negligence, and this means how you, the injured person, may have contributed to your injuries. So you need to address any claims of contributory negligence if the defendant argues that your actions contributed to the attack. Then you need to be prepared to counter this with evidence. Next thing to consider is criminal acts. If the attack by the dog occurred during a criminal act, for example, trespassing, you need to prove that you were not engaged in such activity at the time of the attack. For example, if you're going into your neighbor's yard to retrieve, say, a ball and you're attacked by a dog in that circumstance, then you want to show that maybe the attack happened after you were off their property or that you were not trespassing in some other way. Number five, you need to calculate and prove damages. So, as with every case in negligence, there is proving the negligence and then proving the damages. So, this can be economic as well as non economic damages. So, economic damages involve medical expenses, lost wages, and other financial losses related to the injury. If you miss time at work, then this would be an economic damage that you could claim for. Non-economic damages are pain and suffering, emotional distress damages, and any long-term effects or disabilities that result from the attack. So these are the types of damages that you can look to claim for. Tip number 6, in terms of establishing liability after a dog bite, is to seek expert testimony. So, medical experts can testify about the extent of the injuries, the treatment required, and especially about the long term impact. The other type of expert that you might consider is a behavioral expert, and this would be an expert who could provide insight into the dog's behavior, past incidents, and whether the owner took reasonable precautions. Tip number 7 in establishing liability after a dog bite is to file a claim and build your case. So, first of all, and importantly, you want to work with a lawyer who's experienced in dog bite cases who can help you to navigate the legal process, file your claim, and present evidence effectively. In terms of negotiation or going to court, your lawyer will assist you in negotiating with the insurance company or the dog owner if they're acting in person. A lawyer can help you to go to court if necessary. Tip number 8 is to make sure you preserve the evidence. So, not only gathering evidence, but you also need to preserve any that exists. So, keep detailed records of medical treatment, communications with the dog owner, and any other relevant information. You want to make sure that evidence is preserved and not tampered with, and this includes photos, medical records, and witness statements. So, by following these steps and working closely with your lawyer, you can build a strong case, which would improve your chances of proving liability in a dog bite case. I can be reached at the contact information below, and I would be happy to speak with you about your legal matter.